Dear colleagues, dear non-governmental advisors, dear ICN community, welcome to the ICN Annual Conference 2022 in Berlin. I must say this is an exciting moment for me to have you all in this room, to have a conference of the ICN, an annual conference really in person again. After all this online, we are back on stage again, and this is really exciting. It's exciting for another reason. Today I remember back 17 years ago when we hosted the fourth ICN annual conference in Bonn, and I was in charge of organizing it. I was in the role in which Barbara is today. So this is really coming back to me today. Well, we have a difficult time behind us, I would say. I found this whole time a bit worrisome for the ICN because the ICN is a virtual organization, and I think even or especially for a virtual organization, it is so important. If you have no brick and mortar secretariat, if it all consists only of people that are ready to invest into a certain organization. That's all we have in the ICN. And I think it is so important that if this is so, you meet from time to time. And this is why I was really a bit worried if all the people who make that investment into the ICN would really stay on board, the people on which the ICN depends. But thanks to your engagement, I must say, we coped well with the pandemic. We had two virtual annual conferences, one in Budapest, one in Los Angeles. If you had an idea how difficult it is to find a host for this conference, then you might imagine how sad I was that we could not meet in Budapest and that we could not meet in Los Angeles. And I deeply hope that maybe one day we will have these cities as the venue for one of our ICN annual conferences. Instead, we did lots of webinars. We had spotlight discussions on leading your agency through change and competition enforcement in the digital economy. We had lots of virtual events, sometimes with lots of participants also, always with a lot of participants. The production of the ICN training on demand, video modules continued. We also started new projects like the Bridging project that is bringing together younger and mature agencies in the ICN. We were able to continue our cooperation with other international organizations like the OECD, like UNCTAD. Both are represented here in Berlin. We continued our cooperation with the World Bank. On Thursday, again, we will see the advocacy contest here in Berlin. And we continued our cooperation with the African Competition Forum that is going to have a meeting, the steering group committee that is going to have a meeting here on the margins of this conference. So I think, why am I telling this? I think in the very end we can really say we managed to keep it together. Many thanks to the vice chairs, to the working group co-chairs, the project leads, the secretariat, the horizontal coordinator, and many, many more. There were many unseen efforts behind the scene to keep this large group together. So many thanks for that. As always, a crisis is also a chance. And I think there are issues and things from the pandemic that will remain. First of all, we have learned also about the future, how to deal with such a crisis in terms of technical matters. I said already, we had lots of virtual conferences. Today, this is a hybrid conference. At least what is happening here in the plenary is streamed to the outside world. I think this is very good in order also to organize some inclusiveness with respect to those people and those agencies who cannot be here today, because there are still travel restrictions around the world with regard to COVID-19. So to foster inclusiveness, I think these virtual channels are good. We have also learned in terms of substance, things we can make use of in the future. I talk about the steering group statement here on competition during and after the pandemic. This highlighted the importance of competition for the future, for growth, and for recovery. And it underlined the ability of competition law also to adapt to a changing economic environment, that competition law is flexible enough to be applied stringently and define clear limits. In my perception, that has nothing to do with a lenient application of competition law. This is not what I mean. But if the competitive environment is changing, if the economic environment is changing, well, then this is a moment where a different competitive assessment is required as well. And I think we have very well passed this test in practice, that we can cope with these kind of situation. And again, this is a lesson that we have learned, of which we can make use in the next crisis as well. And we are, to be frank, in the middle of the next crisis due to this terrible war that we see in Ukraine, the war by Russia, an ICN member in Ukraine, another ICN member. And we see again disruptive changes. We see very speedy changes. We see a crisis in energy supply. We see a crisis, we will see a crisis in food supply. Maybe what we see at least is we see a general trend to a high inflation in many countries, in many countries of members of the ICN. Inflation has become a problem again. And then everyone looks at competition agencies, knowing very well we are not price agencies, but who can do something about it, which is the right agency to look at. And we're looked at by policymakers, by the public, and we are wondering ourselves, is this a time where maybe companies are moving together closer than they should? Do we have tacit collusion around? One company say, oh, it's inflation, I rise my price by 10%. The other one saying, oh, inflation, 10%, yes, that's a good idea. No matter how high they should indeed increase their price due to higher cost or shortage of supply. To look at that, to look at margins, to look at who is benefiting from these high prices, again, this is something we have to deal with, because everyone, again, will be looking at us. So the role of competition agencies is always changing. We always have to adapt to changing circumstances. I know, and I want to underline, we are no political organizations. The ICN is no political organization. You know, our credo is, it's all competition all the time. But on the other hand, our work is not detached from policy making, and is not detached from what the public expects from us. So we can do some work on this also in the ICN. When the ICN was founded 21 years ago, there was a huge momentum for competition, for free market economy, and for multilateralism. That also has changed, at least in some areas of the world. I think the political environment for multilateralism, for independent competition agencies, is by far more difficult than it was 21 years ago. And I'm very happy that we have the ICN today to promote the ideas that are behind competition policy, and to promote the idea of market economy with competition policy as well. as the constitution of the social market economy, as Ludwig Erhard has put that many, many years ago, but that should be true for all agencies worldwide. So what can you expect? A lot. There are going to be power talks. There's going to be keynotes, panel discussions, breakout sessions. We will deal with the standard of proof, with cartel enforcement in the next decade. We will deal with regulatory and competition law in digital markets. We will talk about merger control and killer acquisitions, already mentioned frequently this morning. We will discuss how to include sustainability considerations into competition law and the application of competition law. We will talk about the intersection between competition, consumer protection, and privacy. We talk about gender-inclusive competition policy, the impact of the COVID-19 pandemic on our investigative process and international cooperation. There are many more matters to discuss. You will find them all on our agenda. What you also find on your seats is a book that looks at 20 successful ICN years. All my thanks go to David Anderson and Paul Lugard, who have been initiating this initiative. Many, many thanks for that. I think it's an excellent book to take a look back at the ICN. In the coming days, we will not so much look back, we will look ahead at pressing questions by global developments, and we will look at the future work of the ICN. I can only call upon you, participate in all the debates, go to the breakout sessions, make yourself heard, and have a lively debate. And by this, again, I declare this conference to be open. Many thanks. So we will start this conference, a bit unusual, I must say, with two most distinguished guests. We have talked a bit already this morning during our conference about the role of the judiciary, of the courts for our work. Normally, the courts come towards the end of the proceeding. Today in this conference, this is completely different. They come at the beginning of this conference. And I want to welcome, two very prominent judges here, Professor Marc van der Woude, President of the General Court in Luxembourg, and Professor Wolfgang Kirchhoff, President of the Competition Law Panel of the German Federal Court of Justice, just newly appointed beginning this week. Again, all my congratulations, Mr. Kirchhoff. Please join me here on the stage. Marc, you come in the middle. Well, just to give a little bit of an introduction, both of you have not started their career, in fact, as a judge. Marc started his academic career at the universities of Bruges, Leiden, and Rotterdam. He was a competition law enforcer. He was with the European Commission's DG Comp and the legal service. For some years was a member of the private bar as well, so he knows competition law and its application from all sides. He's a judge in the General Court since 2010, and in 2019 became the president of that court. Wolfgang Kirchhoff has made a steep career in a major international law firm. I think it's fair to say that. We don't name them, of course. He worked for several years in the firm's Brussels office. In 2004, he was elected to the Federal Supreme Court, and that is quite an unusual issue because, if my information is right, Mr. Kirchhoff, you were only the second one who was elected directly to the Federal Supreme Court from the private sector. So this is really a rare issue. You joined the Competition Law Panel of the Federal Supreme Court and now leading this panel exactance. We want to talk a little bit about the standard of proof today, because that is an issue for all competition agencies. We have a great and even a growing concern, and that is something that we share, about the complexity of competition cases. Since the last 2 decennia, there was an evolution of competition law. We've seen the more effects-based and oriented analysis of cases. We see a more elaborate development of theories of harm. More economics are loaded into the cases, which means that everything gets more complex. In 2002, a landmark decision, the Airtour's first choice decision, had 296 recitals. The Google Shopping decision had 706 recitals. So you can see by that already what is going on. In the old days, Marc said, a file arrived in Luxembourg on a pallet. Today, it arrives in a truckload. So this is the first issue I would like to discuss. Is this rising complexity a good thing? And most and foremost, who are the drivers behind this complexity? Is it a subject matter in itself? Is it the authorities? Is it the undertakings, the lawyers, the economists, the legislation behind it? Is it the courts? It's all of them. Who's the ringleader? They're all here, Marc and Mr. Kirchhoff. So all possible suspects are to be addressed. Marc, you have the floor. What is your view?
Complexity is a complex question.
Yes, sure.
First, I think it reflects a societal trend. It's not only competition law, but all issues in society tend to become more and more difficult. More and more difficult become also the issues which go to court. And more issues go to court, whereas in the former days they were dealt with, say, informally. So that is perhaps the first element. It's not only us, it's also the world around us which becomes more complex and longer. I would also say that when it comes to competition law, we have more insight and tools. We now have, of course, the economists, which were not there in the 1970s or 80s. I remember one economist in DG Comp doing very detailed studies, and sometimes we would call upon him and he would publish them, but that world has completely changed. We now have a better informed way of looking at things. Perhaps we're overdoing it, and that may also be a second reason. And the third, I would say, is that the stakes are higher. When we took decisions in the 1960s, 70s, I think it started to shift with first the Pioneer case, 1979, 81, then the polypropylene cases. So the stakes became higher and higher and higher. So that may be an element. And a fourth one, which crossed my mind, is to say perhaps there's also a lack of trust. Why do we have to write so many things on paper? Is it because we don't trust the authority? Is it because we don't trust the judge? A question I have, but it's clear that it can't go on like this. But that's my personal opinion.
Many thanks, Marc. Mr. Kirchhoff, it's not different in Germany. What is your view? Where does this come from? This rising complexity that we see.
I think
and maybe do the courts contribute to that by their demands?
I don't think that the courts contribute to the complexity of cases in Germany, but it is true that we see more and more an increasing complexity of competition law cases, and that is true in terms of file volume. It is the in-depth economic reasoning, and it is also, at least sometimes, factual uncertainties. And so court proceedings may tend to need more time. However, I think we all know that only judicial relief in due time is efficient judicial relief. And with the increasing complexity of cases, there's also a certain danger of wrong decisions which may grow respectively. More complexity does not necessarily result in better judgments, and you have to keep in mind that it probably is more difficult to convince a judge of something very complex, which is not obviously likely.
Yeah, many thanks for these observations. So it's all of us, indeed, who are in charge of it. Well, if we think of it, we have to take a decision how to deal with this complexity, because Marc said it can't go on like that. So we cannot just rise complexity ever more. So if this is so, and if this complexity does not lead to better decisions necessarily, there's a usual trias of options that we have. That is, change it, leave it, love it. I think leave it is not really an option, because we are here to make changes. And if we have a problem with the judicial review, if we have a problem with our cases, if we have a problem with complexity, I think the first option could be love it. Do you see that as an option, which would mean that we would have to tackle the issue by getting our institutions in a better position to deal with the complexity? That would mean an intensified use of economic evidence, an intensified use of expert opinions, maybe before the courts. Maybe would have court-appointed experts. Maybe we would have specialized courts or take expert courts to judges. What we have done in the agency is we have differentiated very much. We have senior economists, we have economists, we have teams that are combined of lawyers and economists. The courts have none of this. They're just lawyers, not just, but they are lawyers on the bench having to deal with cases coming out of agencies of that complexity. So would that be an idea to enrich the courts with experts or whatever, with more expertise on these kind of issues? Marc?
I would say the first thing is, I think the distinction to be made between the procedure and getting all the people in and getting informed decision making and listening to people, listening to economists and other experts. That's one thing. That's the procedure. But then there's the decision. The decision should be short. There's no reason to have a complex and a long decision. And that comes back to the issue of trust. I think if the people had their day in court, could express themselves, we don't need those long decisions. That's my first point. The second point comes to specialization. Specialization has its pros and cons. Of course, if you take specialized judges in an international court, that's not an easy thing to have, because we are there for 6 years. It's a general court, and we heard about the fact that general courts, by the way, we're not specialized, and we're not specialized in digital markets either. Wolfgang, do you know what kind of device this is?
Oh, Marc, I can tell you that is a mobile phone, but I'm a judge from Germany and not from the US.
Okay, thank you very much. So you see.
Okay, we got it.
We do not necessarily need experts. We can help each other with our generalist knowledge. So that's the first point I would like to make. And specialization, in a certain sense, can make matters worse, because it becomes an internal discussion amongst specialists. And of course, when it comes to EU competition law, I don't know whether that is true, of course, for the German competition or for the many other competition laws of the members of the ICN, is that it should not drift apart from its origins. And its origins are in the EU treaty. They interact with other provisions of the treaty. So they interact, or they may not interact, we will see that in the Facebook case, with privacy rules. They interact, for example, with sector-specific rules in the telecoms business. And that was also the discussion, how many missions do you entrust to an authority? I think it's very important to keep some kind of generalist view on competition law. Finally, on economic evidence, that's a question we always get. we have an open stance on evidence in Luxembourg. People can produce their reports. They can, depending a bit on how it fits procedurally in the system, express themselves. So there is no negative stance toward economic evidence. And moreover, what I would like to say, it's not rocket science either. So it is at the level, I think, of most judges. It may take some time to digest, but it's easily doable. And I think on the judgments we deliver, I don't think there is criticism on the failure to understand the economics at stake. But that's my personal view. I don't know whether that reflects the view of my other colleagues, and some of them are in the room, and they may have dissenting opinions.
Yeah, I mean, more judges, more opinions.
Yes, more judges, more opinions. I think in Germany we have a slightly different view on specialization, and in particular given the economic complexity of competition law cases. And so I think we made very good experiences with our specialized competition law panels at the appeal court level, in particular in Düsseldorf, and also with us at the Federal Court of Justice now. May I take the occasion to say a few words about economic evidence and
Sure.
expert opinions? So it's certainly true that we have a lot of pitfalls and difficulties of economic evidence in competition law cases before courts. Why is that the case? That is the case because the task of the economic evidence is usually to construe a hypothetical model. And the hypothetical model may be the as efficient competitor, that may be the market price not distorted, or it may be a model to predict a prospective market development after a merger. And all these models are means of circumstantial evidence only. They provide judges with a certain degree of likelihood of a specific competitive scenario. And that is in a let's say, usually I would really say a sharp contrast to the standard of beyond a reasonable doubt we usually have in Germany, mostly, I would say in principle in Germany. Model premises are often disputable and maybe not appropriate for the case at hand. And the theories, that is not my creation, I heard it somewhere, the theories may be well-funded, not well-founded, that can appear. All these circumstances increase the complexity of competition law cases, and that is an issue growing to the extent economic evidence is becoming more important. I think that is one downside of the more economic approach. We had dominating EU competition politics for many years, and to cope with these uncertainties, expert opinions are supplied to the courts. If the parties submit them, they have to be taken into account by the court, provided they are relevant, and to decide whether they are relevant, the court may need his own experts. That is possible. And sometimes judges may escape that problem if they come to the conclusion, whatever the result of the expert opinion will be, there will still remain a competition law infringement or a restriction of competition.
Marc?
May I add one point to this? I think the role of economics, of course, depends also on the theory of harm, which the agency put forward. If it's entirely based on economic assumptions or economic theories, obviously economics will play a greater role than when you go for a more straightforward theory of harm based, for example, on other concepts than economic concepts. So it depends a bit on the case.
May I ask, do we develop too complicated theories of harm maybe in the agency? I mean, is it easier if you have a clear-cut theory of harm before your eyes, and maybe you can follow through the case and look if this is proven by the agency?
Shall I?
Yeah, sure.
Olivier Gerson said this morning an interesting thing. He said Articles 101 and 102 and the equivalent provisions in other systems are very open norms. So if the theory holds water within that very, say, open set of norms, why not? Why not a more straightforward theory?
Yeah.
If you come to discrimination issues or fairness issues, that's completely different than, for example, price effects.
Yeah, okay. Mr. Kirchhoff?
It may be sometimes the case that the theory of harm put forward by the NCA is very complex and maybe also a bit, let's say, difficult to understand, and that then the competition authority may face difficulties certainly to win the case. In those cases in Germany, it is not excluded. It is a possibility to support the case by another theory of harm, and even the court may find another theory of harm as long as the facts delivered to the courts and to the court and the facts available for the judgment allow that, and provided that the character of the decision is not changed, that there is no other a kind of prohibition or so, and moreover, of course, the rights of defense should not be inappropriately restricted.
Our system is not exactly the same as the German system. We have a system where the authority takes the decision, and that sets the scene, together with the application brought by, say, the undertaking concerned. We don't have the same liberty, for example, as a German judge in substituting the reasons which underlie the operative part of the judgment. So it may even be that, whilst we think that there may be an infringement, if the application is not correctly made or if the decision is not correctly drafted, we are bound by that. So our leeway in the system we have is different from the leeway of the German review courts.
Yeah. To conclude our very short panel, I want to come back to something that Christina Kaffera has said this morning. Shall we go back to assumptions? I mean, we have many approaches that we could take. We could look at effects, we could look at potential effects, but we could go beyond that, as we did maybe in previous times, and work with assumptions in order to really make an effort to cut down the length of trials, the length of procedures. Can you imagine that this is a way forward in a world where we so much got used to not talking about assumptions anymore, but talking about effects or potential effects? Is that a way out?
I will give an answer as a lawyer, it depends. So if you have sanctions, you have huge sanctions, one could argue that you enter into a criminal sphere. Working with assumptions in the criminal sphere is another thing than when you come to authorizations for a merger, or, for example, the mere fact that you state that there is an infringement. So I think when you are in the sphere of the law, which might be governed by Article 6 of the Convention of Human Rights, it's more difficult to place assumptions or presumptions than when you are in a more administrative setting. Now, this being said, we say the case law relies to a great extent on presumptions, and that works by, in fact, the burden of proof. Party one says this, and then the other party says, no, that's not exactly it, it's that. And then the burden of proof shifts on the first party. So we have that system already in the classic rules of shifting burdens of proof. And we have it inbuilt in our case law, for example. The typical case which always comes up, is it tacit collusion, which necessarily derives from the market, or is it an explicit and overt type of cartel? And in your introductory words, you mentioned it, and they did a 10% rise. Is it just inflation, or is there something else behind it? You could say, okay, it's tacit collusion, but then it's for the authority to prove that it is not. Parental liability is also a thing where we work with those presumptions. But again, everything, I would say, depends on the procedural setting in which you are.
Marc, excuse me if I insist. What about economic assumptions?
Could you give an example?
Yeah, like we had maybe, it played a bigger role in merger control in Germany in former times,
Yep.
that if you had a certain market share, I would not say it was a presumption of the hard part, but then it was very likely that we would be able to forbid a merger, to put it very bluntly. I mean, we have problems with complexity, especially in digital mergers, when
Yep.
looking very far in the future. And we must wonder and ask ourselves, as I said this morning, if we let uncertainty hinder us as agencies to prevent mergers, of which it is very, very difficult to prove that they will do harm in the future.
If you have a combination of a high market share and high barriers to entry, I think it's reasonable to presume that there might be an issue. So that's already in the guidelines, that's in the case law. So I think it's basically, in a certain sense, the common experience of the authorities and the courts, I would say. If you have those two indicators, I wouldn't say it's a presumption, it becomes a serious suspicion.
Okay. Mr. Kirchhoff.
I think assumptions which shift the burden of proof, be it assumptions from case law, be it even in some specific circumstances, assumptions in the law, can be quite helpful to solve issues of complexity in competition law issues. For instance, I think two of the major merger control cases in Germany in the last decade, Total, OMV and Phonak, they were decisive in that context were the so-called legal assumption for market dominance in oligopolistic structures in German law, which tells us that 5 or less undertakings forming a collectively market-dominating oligopoly. And then it is possible that the parties may rebut the assumption. There may be, for instance, efficient competition, notwithstanding the oligopoly, as we found in Phonak, but not in Total. Yeah. And however, if you arrive in a non-liquid scenario, that means that it is still open whether there is efficient competition or not, then the assumption will prevail, and that would mean that the merger prohibition would hold before the court. Do we have still time to
1 minute?
Give 1 minute about other possibilities to overcome the issue of complexity in competition law cases? I think it is very important to keep in mind that to impact these difficulties, we should recognize values like consumers' choice and freedom to compete as legitimate purposes of competition law. And that is something you can see in our recent Facebook and Booking.com judgments. In particular in Facebook, we found that consumers should have a choice between a more personalized or a less personalized account at Facebook, and that would usually be the result of workable competition. And if we can point to values like consumers' choice and freedom to compete, you can reduce, of course, the impact of expert opinions and strict economic evidence. But what is important still are surveys carried out by the NCA. If these surveys are according to the standards which are acknowledged, and if you can really use them, then that is also a valuable source to decide competition law cases.
Many thanks to both of you. I think we have heard very important vocabulary today: common experience, consumer choice, freedom to compete, and I think these are all scenarios with which we can work and with which maybe we can make it work also in the digital economy. So many thanks for this insight. Burden of proof at the courts, we will try to deal with it. We will try to deal with it. Many thanks and a great applause for you.